There's an inquiry about an H&C, or Humanitarian and Compassionate application. And let me just get that closer to the camera so it looks like I'm speaking to you. This is for in-laws, I suppose parents. And the question is there a successful procedure? And so I'm presuming for the moment, the person who posed the question is talking about humanitarian and compassionate for parents. If not, then please clarify. But for parents doing an inside of Canada humanitarian application, as the name implies, they have to be inside of Canada. And the other component used to be characterized as unusual, undeserved, and disproportionate hardship. So technically, that particular phraseology is not necessarily the basis for this, but some of the synonymous types of circumstances that would increase the chance of success for parental-based humanitarian and compassionate are, for example, country conditions where their passport or their ordinary country of residence is, and, for example, is there a significant degree of crime which is not given sufficient treatment or effect to reconcile by the police in the country? Similarly, are they a minority in the country where they hail from and are unable or unwilling to get government protection, such as police? Another factor is, for example, their degree of economic establishment, because a humanitarian compassionate application does not have the 20-year promise that the would-be sponsors, namely the Canadian Child, has imposed on them as a precondition to sponsor, because the normal requirement to sponsor requires 30% over the low income cutoff. And that is there because the government wants assurance that if in the 20 years after your parents get landing as permanent residents, that if they take social assistance, you will pay for that. That's why there's a low income cutoff. By contrast, a humanitarian case does not have this requirement. So there is a particular concern that the parents may not be taken care of by the would-be son or daughter who is promising to take care of them. So the short answer is financial support by the quasi-sponsor, because they're not sponsors in an H&C case, and also funds by the parents. Other factors would include the health of the parents, because people age and entropy leads to possible excessive burden on the health or social services of Canada. And that's something of an anathema given the current state of events in Canada, where there are concerns about immigration increasing, and there are government policies such as not having an official lottery for parents during 2021 up to 2023 inclusive. So given this sort of political climate which is affecting immigration, those are other factors to keep in mind. So the other factors that come to mind are the other children of the parents. For example, are there children in the country where they hail from who could take care of the parents? That could be something that may make the chance of success lower for an H&C related to parents. I'll take a quick look at the questions here. So this may be relating to a different matter. Before I leave that, I'm just trying to sort of calculate in my head if there's any other issues or criteria related to the chance of success for parents. And I can't think of any off the top of my head, but if there's a follow-up question, then please let me know. I'll just proceed to the next question. which relates to a TRV, a temporary resident visa, aka visitor visa refusal, 3 times for the spouse of somebody, presumably in Canada, spouse and daughter. Daughter is a teenager. The purpose expressed in the visitor visa was for the host in Canada to meet the teenage daughter. And I think it's touching upon a policy relating to work permit. So a work permit is possible depending on the status of the host. If their host is on a study permit or work permit themselves, then the spouse could come to Canada and convert their application to a work permit. But the kind of focus of this question is how to deal with the rejection and turn the rejection into success. So in some senses, the TRV, being a visitor visa, has inherently a lot more discretion connected to it. And that means the officer can feel free to refuse the application on less robust grounds than are required, for example, for a study permit or for a work permit, where there are more specific criteria. So in a visitor visa, the typical basis for the refusal is that the officer does not think the person will return to their country of ordinary residence or their country of citizenship. And the reason for that oftentimes relates to which relatives are in which country. So if there is a stronger relationship such as spouse in Canada, then that means that would have to be addressed because there is a presumption that the spouse in Canada is what's called a kind of a pull to Canada. And similarly, if there is a lack of establishment in the home country, then in that case, this could be a concern that the person who is seeking the visitor visa may want to work illegally or may not be inclined to leave after their visitor visa expiration is elapsed. So in these cases, in a sense, the context and detail are kind of the buzzwords you have to keep in mind for a visitor visa application. It's more complex when there's a refusal because then the context and detail that you have to provide to the immigration officer has to include the visitor visa refusals. Why did they take place? What was filed in those visitor visa refusals? What is being brought to the table on this 4th visitor visa application that may assuage the officer about the concerns that were expressed in the previous visitor visa refusals? In some cases, if you look up on what's called CanLII, there's case law that talks about visitor visa refusals and what constitutes a reasonable or unreasonable refusal. If you're well versed in the English language and are able to digest and add case law to a submission, then that would enhance the chance of success. So the bottom line is visitor visa applications are highly discretionary. From my point of view, probably the most discretionary. And if you have a negative record, such as non-compliance or refusal of either a Canadian visa refusal or non-compliance with any kind of immigration laws of other countries, the chance of success may be lower unless you can contextualize why the visitor visas or foreign immigration visas were refused in the past and not make it look like there is some form of non-compliance, which leads to the concern that there may be a potential non-compliance if the immigration officer grants a visitor visa. So I hope that provides some context for this. there's a little bit of a follow-up, just to provide me context to that question about the visitor visa refusal. So the question has more detail relating to the fact that there are children who are permanent residents in Canada, and there is a lack of income, so sponsorship is not a possibility for this. So this becomes kind of complex. Let me just make sure I've got the right context for the right question. So in this case, the fact of the person with the visitor visa does have employment in Canada. So that leads to the option of filing for a work permit outside of Canada in the case rather than a TRV, because the spouse is in Canada on a valid work permit. So the other concern would be whether the skill level on the work permit is at a certain level. I believe tier 3 or higher has to be the required amount of skill for the candidate to file for a spousal work permit. And so I hope that provides some context to this. There could be a follow-up related to the H&C. So with the H&C, the children are all in Canada, the H&C for the parents type question. And so sponsorship is not an option because they don't have the requisite 3-year income. And I would sort of add to that, saying that there hasn't really been a draw, a lottery, unless you were in the parental expression of interest pool from 2020. So that's another barrier, which in turn leads to the reason why people are asking for parents being sponsored, or not sponsored, that's the wrong word, but parents seeking permanent residency on humanitarian and compassionate grounds, which we do seem to get a lot of queries in the past 18 months or so. So I hope that provides some scope or background to that kind of issue, and feel free to bring any more questions about this, because I'm free to pose your questions for another 40 minutes or so. And in case there's some follow-up questions to what I've said, then please let me know. In the meantime, the sort of governing principles for how to deal with immigration depend on which department you're dealing with. So, for example, if you have a border interaction, good advice always is to listen to the question and answer the question truthfully, because every border official of every country, including Canada, wants to hear that. So in the case of a situation where you are not conversant in English or French, they should be able to get an interpreter for you on the phone if you have some kind of more complex interaction, such as presenting a study permit or a work permit at the airport. So that's sort of a general principle to keep in mind when dealing with border people. And similarly, when there's an application of any sort being filed with IRCC, look at the question being posed and answer the question. And the other general principle is do not leave gaps to things like address history, or else the application will get returned. And it's quite possible that the starting date for the processing would be when the application is resubmitted. And that's a concern. If, for example, there is a time-sensitive program, such as filing for a dependent child who is under the age of 22, and you can no longer sponsor them if at the time you resubmit the application, they're over 22. So that's a concern. to keep in mind when dealing with immigration. Another common question which comes up is, when can I do an application by myself? And when do I need a lawyer? So since there is an audience here, in some cases, if you're doing an application and you're a skilled worker, you work for a Fortune 100 company, you're fluent in English and French, there's no issue about your work experience given the place you've worked for, you might be able to do this application on your own. However, if you're a professional person who's worked for a Fortune 100 company and had a criminal interaction, such as a drunk driving offense, or had a previous misstep with any immigration application from any country, you may consider the need to have legal advice, because this would add complexity, and there could be a concern of some potential non-compliance by the Canadian immigration authorities if they see that there is a possibility of inadmissibility due to criminal activity, such as drunk driving, or previous non-compliance with another country's immigration laws. And you'd need a lawyer to explain that, or if applicable, make a submission for rehabilitation or a temporary resident permit. The former is based a requirement for criminal activity after 5 years have elapsed from the completion of a criminal sentence. The latter, namely a TRP, is required when there is an offense and less than 5 years have elapsed. So rehabilitation is not available. And also if the concept of deemed rehabilitation is not available, namely if 10 years have not elapsed from the completion of a sentence that was a criminal offense. So that's the sort of the background. Commonly asked questions which I kind of see on online forums that I see sometimes. And then there's a follow-up to the H&C question. And again, relating to the H&C for parents, there's a certain age, 65 and 70 years old for the parents. And the question is, can they apply for an H&C alone? I would say 99.999% of the time, you should never apply for an H&C application on your own, because although the name H&C, namely Humanitarian and Compassionate, sounds based on the words like they want to elicit and are welcome and have a sympathetic voice, that's absolutely not the case. An H&C application is being done by a civil servant with some training in Canada's immigration manuals. And immigration manuals are meant to cover contingencies and broad-based scenarios that they're trained on. And they're meant to guide officers about how to make a decision in accordance with due process or procedural fairness, and to not make a decision that is unreasonable. What that translates into is that in many cases, as long as they've considered what you have submitted, then that's pretty well all they have to do. So if they, on the other hand, if they deal with a case that is addressing the best interests of a child, they have to consider it with a bit more sensitivity. If their notes show that they considered the best interests of a child with some sensitivity, they could still deny the application. Similarly, with an H&C application, if you don't contextualize a bunch of documents, like country condition documents, or the degree of economic establishment of the children in Canada who intend to support their parents, the officer can say, I don't think the support system is adequate for these parents, and they could deny the application. Some people who are well-versed at Googling lots of documents, they will produce a plethora of documents for an H&C application. And then expect the officer to go through 500 pages of country condition documents and fail to provide context. If you're a highly literate person and are able to digest those documents and provide context to those documents in relation to the lens that the officer has to have when assessing these applications, the lens, namely, that is partaken through the immigration guidelines that are given to them, then yeah, it might be in some cases possible to file a humanitarian compassionate application on your own. But then you also have to be well versed in the case law, and there are thousands of cases that relate to these types of situations, and they deal with what constitutes a reasonable or unreasonable decision. So you have to be well armed with those positive cases because you want to push this very discretionary application over on the positive side. I talked about visitor visa applications being discretionary, and this is right up there in terms of the most discretionary applications an officer can dispose of. And I mean dispose of as hopefully a positive decision and not disposed of in the form of a negative decision. So there's a ton of documents. There's case law you should research and try to look for that is positive to give more further guidance to officers, which tend to only be familiar with their government guidelines and not with the thousands of federal court cases that are out there. At the same time, if there is a negative case that might resemble your case, you might want to contextualize that case as well. So the short answer is don't ever file the humanitarian compassionate case on your own, because if you get a refusal, that's one further negative mark against you. And then if you're considering refiling, then you have to address that agency application, forcing the officer to deal with more things to contextualize and deal with. So that's sort of the short answer. I hope that was of some use. So there's sort of a issue in the chat where there's follow-ups to two different questions. So I might be mixing up the facts, and I hope I don't do that, but give me a second. So relating to the TRV, a very popular application. So the invitees stay in the United Arab Emirates, which is the, it looks like the daughter is in Canada working. The daughter, working in Canada. And the goal is for the daughter to get a TRV for the mother and another daughter remaining in the United Arab Emirates, I believe, UAE, right? Or Dubai, right? And then the asker of the question is working in Dubai, and there are strong ties, which is a criterion for a visitor visa, to the home country, which is not Dubai, in the form of real property, land. And so there's some frustration because the officer apparently might have had access to this information and still refused. And so for this, there's a bit of complexity in this situation because a lot of South Asian people work in the Gulf, Bangladesh, India, Pakistan, Nepal, etc. So by South Asian standards, there is a good degree of establishment because they have a good job in the Gulf. But there's one technical issue, which is that in most cases, you work in the Gulf at the pleasure of your employer. So experienced officers might query, what is the nature of your work in the Gulf? If you're a white-collar professional, then they might deem you to have a decent amount of establishment. However, if you're an older worker in the Gulf who may not be able to demonstrate that they can work longer, the degree of establishment might be less. So it's a double-edged sword. Then they might have the concern that your employment might be terminated from the Gulf and you might be left stranded going back to your country of citizenship, which might be India, Pakistan, Bangladesh, or Nepal. So you have to really explain a bit more about this type of sort of hybrid establishment, which is in the form of maybe assets in the country that your passport is from versus and or buttressed by the establishment based on your job in the Gulf, which might be a good job by South Asian standards. So that's another issue which you have to enlighten the officer about. But really, after this, I've heard of many anecdotes where people do apply multiple times. And if the need to visit Canada is stronger, if there is a stronger purpose, then that should be addressed. Otherwise, the officer can think, well, the person can just leave Canada and visit their daughter wherever the daughter is, such as in the Gulf. So I hope that provides some kind of context for this kind of case. So I hope I've answered all the questions. Everybody's still here, so I always like to do the sort of public service type of Q&A if there's no particular question, but no, I do see a question, right? So that is, the person has already been issued a visitor visa with the help of an agent. And the question is how to secure a job on arrival or before arriving. So in this type of case, this is a common question for me because there's a brief video on TikTok where I said this is theoretically possible. I did have about 4 caveats for this, and out of the perhaps 150 TikTok videos, this one video, which had the title, I think it was "Convert Visitor Visa to Work Permit," had, I think, 30 times more views than the other one. So I mean, I think this had like 11,000 views. So you have to keep in mind the basics, which is that if you're on a closed work permit, you already have a work permit, and then you can, while you're inside of Canada, convert to a different kind of, or if you're being offered a closed work permit job, namely to one employer, and if you're in Canada, you can convert that. But the premise is that you have a job offer already. The reason that you have to have a job offer is that that job offer either is going to transfer your unique skills to the Canadian labor market, or you have proprietary knowledge that the would-be Canadian employer has. So you're still not competing in the Canadian labor market. And then the other way to get a job offer is a labor market impact assessment. But when you look at the criteria for a labor market impact assessment, that application has to be done by the employer. So the employer has to show that hiring a foreign national will have a neutral effect on the Canadian labor market. Because, for example, the would-be candidate who would be given the LMIA is going to transfer skills to the Canadian employer, which are not readily in demand in Canada. So, in other words, you cannot disturb the Canadian labor market with precious few exceptions. That is, if you are on a visitor visa and you meet somebody and you get married, or you've been common law in Canada for 1 year, and then you can change your valid existing, subsisting visitor visa to an open work permit because the government thinks it's okay to compete in the labor market so that you can get on with your life because eventually you'll be staying in Canada with your spouse as a permanent resident. So if none of these situations apply, if you don't have an LMIA or if you don't have a job offer that's on a closed potential work permit with a single employer, then you're left looking at the Canadian official job bank for a Canadian employer who's looking for somebody with very specific skills. In theory, you may find an employer who wants to have a restaurant supervisor in a very isolated part of northern Manitoba or northern Saskatchewan or northern Alberta, and they cannot find anybody no Canadian wants to work supervising in a small restaurant in rural provinces. So for that reason, employers will post on their on the job bank looking for a Canadian, a non-Canadian who obviously is outside of Canada and is gladly willing to work as a restaurant supervisor or is willing to work processing meat in a factory in Alberta because Canadians may not want to do that job. Similarly, by the same token, there are pathways for permanent residency for people with truck driving experience because, again, Canadians don't want to do long-haul truck driving. They don't want to travel from Edmonton to Texas, which could take 5 business days or something. And so if you do have training as a long-haul truck driver, you might very well find a job offer on Canada's Job Bank, which I believe is jobbank.gc.ca. That's the website. So you can look for a job because we have to protect the Canadian labor market. If you're a savvy reader of the news, there's a minor scandal all over the news in the past 2 weeks because apparently there's 2 million temporary residents in Canada out of a population of about 40 million. So there's a concern about what did we promise these people, because education agents who are unscrupulous and unethical told a bunch of South Asian people in India and Pakistan and Bangladesh, just get a study permit and it's smooth sailing to permanent residency. That is no longer the case right now. And now there's a government sort of backtracking about this. So this is affecting all the temporary applications, including visitor visas, work permits. There's a lot more scrutiny going on by the Canadian Immigration Department. There's rumors that at times officers are told, I don't know if this is true, officers are told just to refuse these cases, either because there's too many and they can't process them, and they refuse them because very few people challenge them in court, or refuse them for some other reason. And that leaves people in the dark, especially if the basis for the refusal is not rational. So that's the kind of state of the affairs when dealing with temporary residents. There's too many right now in Canada. There's a concern how to transition them to permanent residency, because if they don't, and if they're young, they'll take the chance and maybe become illegal. And then there's an enforcement problem. That could make the current government very unpopular if the data comes out, and it eventually does, that there's X amount of people who have not been tracked in Canada and don't have status, and there's no record of them departing. So this affects what is called the integrity of the immigration system. This leads to the opposing party calling for more stringent measures to deal with the potential underground plethora of people. And this happened 10 years ago. And then there was numerous laws and numerous increases in funding away from the Immigration Department to the Canada Border Service Agency. That's bad news for people who want to settle in Canada. Paradoxically, it's good news for immigration lawyers who do what is called enforcement work, because then there's a litany of enforcement, and that leads to removals and deportation and all of that sort of thing. It's highly stressful for the clients who are underground and are subject to enforcement measures. So there is a kind of pendulum or a kind of yin and yang to immigration policy. The legacy of these some 2 million people are the fact that the previous government wanted to have a pathway for people with Canadian education and work experience. So they deployed the express entry system. where you have 1 year of Canadian work experience after graduating from a Canadian school, and that used to be enough. And now that's not enough. You have to have fluent English, a brother or sister in Canada, maybe 3 years of work experience outside of Canada, 2 years of work experience inside of Canada, and a master's, at least according to the last couple of draws. I mean, that could go down because maybe the amount of qualified candidates will become less, and then the points will go down to a situation where you don't need all of those things, but you merely need just Canadian education and 1 year of work experience. So that's sort of the sort of impact of the political aspects on all of these applications. So I'll just look if there's another question, right? And that relates to provincial nominee, and that is the process for permanent residency under the Ontario Immigration Nominee Program. So for the OINP, there's different streams. There's the human capital stream and the job offer stream. So I think the universal rule with this is that it takes somewhat longer for the job offer stream as opposed to the human capital priority stream, because the Ontario government has to vet the job offer, the company providing the job offer, rather. So the other concern for any immigration nominee program from any province is that you're adding an extra layer of scrutiny as opposed to the regular federal express entry system. So now you have a province assessing you and or the would-be employer who is saying they're going to hire on a long-term basis. So that could take perhaps 6 to 12 months. And then once that is done, once the province has done their assessment of you and or the employer, depending on which stream you applied under, then the federal component has to take place. So you file a bunch of federal forms, immigration forms, for the purpose of assessing your admissibility, such as criminal and medical admissibility. And at the same time, the federal authorities sometimes take a long time because this is a dirty secret, but sometimes they take a long time so that they want to make sure you still have an ongoing relationship with your employer. And they may ask, tell us, are you still employed with your Canadian Ontario employer? If not, then your application could be denied and say, well, the whole basis for this is no longer present. So that means in excess of maybe 2 years in some cases could be the processing time if it's an Ontario immigration nominee or any PNP program pathway for permanent residency. If you think about how the government thinks about it, it's, well, yeah, we're slow because we want to make sure you're still employed in that province. Because there's a concern, especially in the smaller provinces, that you may not really want to be there, or maybe you're not needed in the job in the smaller province because of a downturn in economic activity. So by delaying the application, this provides an extra layer of scrutiny on your PNP or Provincial Nominee Program based application. So that's why the processing time is longer. In the federal government's defense, they say, well, you should be happy you're working. You can always apply for what's called a bridging open work permit, so you can continue your work life and your career in Canada before you get the PR. So there's not much you can say in that circumstance, unless you want to get a job that requires permanent residency, like maybe in the Canadian military or in some other kind of job, right? So that's sort of the background issues related to the processing times for these cases of PR where there's a provincial nominee program involved. So I think hope I've covered all of the questions. If not, you can repaste the question. And if there's no question further, then there's always the sort of public service announcements I give to people considering immigration interactions. But let me just take a peek at the text here, the chat, right? So I think it relates to the TRV, temporary resident visa / visitor visa application. And that is that if the intention for the purpose of the visit to Canada is clearly expressed and all of the relevant documents showing the intention and showing the establishment and ties to the country outside of Canada are presented in the TRV application, is the option available for a federal court? So the short answer is yes, but like every lawyer in the entire world, it's always yes, but, because we always want to provide context. And so the idea is that every competent or every ethical lawyer will always want to assess the chance of success. We don't want to go to federal court willy-nilly, because that damages the federal court system and it damages the lawyer's reputation. So we always ask for the documents that were presented before the refusal, and then we compare them to the reasons for refusal. And then we say, it looks like, based on the reasons for refusal, the officer did not seem to consider this amount of economic establishment as presented in the documents, or did not consider the high degree of responsibility in your job, which means you're making good money and you're highly incentivized to return to your job, or they did not consider immovable assets in your country of passport that you possess, or you failed to consider the best interests of a child, or these sorts of factors. So, in other words, we're looking for either a lack of what's called due process by the Immigration Department, which is the same thing as a lack of procedural fairness before refusing the decision, which means there's a high chance of success, or we're looking for what is called an unreasonable decision. So the definition of unreasonable in the immigration legal context is, for example, making a finding of fact that does not accord with what was presented. For example, the officer saying, I don't see credible proof of employment or property outside of Canada, when in fact there's a very clear letter saying this. Or I see that I'm concerned this person will remain in Canada, but make no comment on the work obligations that the person has presented. And then in those situations, then we say there is some decent merit to the federal court case against a negative visitor visa refusal, for example. So I just going to take a quick scan of if there's any other questions. And somebody said, have a nice day. I guess they left, which is very nice of them. So I don't think there's any other specific questions, but if there's people here, then there's always the idea of what to deal and how to deal with immigration in the absence of any other specific questions. And I've already talked about when to get professional help. For example, if there's something a bit complex, such as a previous refusal or medical or criminal issue in your past. Another type of complexity is just the inherently complex applications, such as the aforementioned H&C, or Humanitarian and Compassionate. Similarly, business applications, such as transferring a worker to Canada, or a labor market impact assessment. Those are really complicated, and there are consequences for the employer. Even after the person has worked for 1 or 2 years and has moved on, the employer may get audited. So you want to make sure that the foundation for those types of applications, business cases, intra-company transferees, humanitarian compassionate cases, those are dealt with professional assistance. One case which is on the border is a spousal sponsorship, where there's a history of refusal, because then there's a concern about For example, if the refusal relates to responsoring the spouse that was refused, then in some cases, officers use their discretion to not even look at the second spousal sponsorship application on the basis of what's called res judicata, which means the same parties and the same application are being submitted to the immigration department, and they're allowed to not look at the case. So that's another example of something where you need legal assistance from a professional, like a lawyer or a licensed immigration consultant with a good reputation. So that's sort of some background for the sort of best ways of dealing with immigration and sort of a hierarchy of more complex versus less complex cases. And so to give kind of a lens of what is kind of the lay of the land in terms of what officers are looking at and what challenges that you may face depending on the type of application you're considering. So in terms of other types of general kind of guidelines, as opposed to specific legal advice about a specific case, there's always the common sense type of things, which I've talked about when dealing with the border service agency face to face. The other kind of concern is people forget that they may have had a negative interaction, like a negative visitor visa from another country. So you have to be very careful in the standard immigration forms, which have the yes/no questions. People tend to just click no on all of those without thinking because they think, well, I just forgot. But one of those questions, there's a specific minutia, which is, have you ever been denied a visa to any country? So that's all encompassing. And you may have forgotten. And now in this case of higher surveillance between countries, namely the 5 English-speaking countries, they have information on your immigration history. The 5 English-speaking countries being New Zealand, Australia, the UK, Canada, US. So if you omit by accident your visitor visa refusal to the United States, they can accuse you of misrepresentation, leading to a 5-year ban. So that's of some concern. Simply forgetting something or not looking at the forms very carefully, particularly at the yes or no part of the standard form, right? So I'll just take a quick peek here if there's anything else for this, right? So that's sort of generally the type of sort of general guidelines again, since I don't see any other question. But yeah, if you, I should say, if you want to retain our law firm for any legal services, you can text us at our phone number 416-447-6118, or you can email us through the website, and then just pose the question, and we can determine if this is something that we think we can help you with, such as the more complex things like a denial of a visa, and which may necessitate federal court, depending on the type of case and the type of documents submitted for these sorts of things. So if there's any other sort of general guidance, I'd say there's always the question of which lawyer to choose. And there's hundreds of great lawyers you could select from. But the concern is also, do you have sufficient clear communication with your lawyer? Because immigration case means there's a significant degree of back and forth that you have with your lawyer. So at the same time, lawyers always demand you tell us everything, because if you omit something, then an application can blow up in your face, and then nobody's happy, because then you've expended money, we've expended time for this. So there has to be some degree of comfort with the lawyer you select, no matter who they are, right, for this. So this is why there's this problem where there's unlicensed agents in the country where you reside from, and they're unlicensed, and they may have a good reputation. And that reputation may be enhanced because they have highly developed indigenous language skills in the language you speak. But at the same time, they may not be fully conversant with the law. And they may do something which they think is fine, but which constitutes a material misrepresentation and leads to a 5-year ban from Canada. There's even sometimes these agents may have connections to local government officials, and you may get a government document by, for example, the agent bribing somebody in the government department, and then that leading to the discovery when immigration calls the government department and they don't have the appropriate record matching the document you're presenting. And that's not only a 5-year ban, but that could be a criminal issue, because tendering government documents which are fraudulent is a crime in Canada. So that could lead to an even more serious issue apart from the 5-year ban. That could mean equivalency to an indictable offense in Canada, which is much more serious. So that's an extreme story, and it took place a long time ago. But that did happen, and as a result, that person could not have their orphaned child immigrate with them from, I forget which country in Africa, in Canada. So there's a huge tragedy because of that. So in the absence of any further questions, feel free to pose one, because I don't want to keep posing sort of very negative anecdotes, which are illustrative, but we want to keep this sort of general as possible in these types of situations. So in the absence of anything else, I look forward to seeing any other question. But if not, then we've covered sort of the frequently asked questions, such as when to do it yourself and what types of interactions can you expect at a face-to-face Canada Border Service interaction. What element is necessary for hiring a lawyer? I've touched upon one of them, and there's many others, right? The other ones could be if it's a particularly complicated case, do you have experience? You can ask the lawyer dealing with this type of case. And that could give a clue about what types of scenarios could entail with your particular case. Assuming the lawyer has experience, then they could articulate the types of scenarios that could take place. For example, at a different venue, after refused at the immigration department, what could happen at the federal court? And the experienced lawyer could tell you the various scenarios, right? So that's another question to ask if you're looking for a lawyer on an immigration type of matter. So in the absence of this, we're getting close to the end of this. So unless there's any further questions in the chat, then I'll just take a little peek at the chat. And I hope this was helpful, because I don't see any more questions. So thank you for reaching out. I hope this was of some utility for the people who have attended. And if there's any further information, you can reach out to us on www.chaudharylaw.com, and then you can phone or text us 416-447-6118. And or you can also text us at that number as well, if you want to text us your email address or something, for example. So in the absence of anything further, thanks for reaching out. I'm going to terminate our session for today. Have a good afternoon or evening, as the case may be. Bye-bye.